Good evening, everyone. My name is Chris, and this is my video discussion post for week 3. For my discussion post this week, I chose to discuss the court case of Obergefell versus Hodges. This case is actually about several related cases in the states of Ohio, Michigan, Kentucky, and Tennessee, where groups of same-sex couples sued their relevant state agencies over their state's bans on same-sex marriage or refusal to recognize legal same-sex marriages. The plaintiffs in each of these cases argued that these bans violated the Equal Protection Clause, Due Process Clause of the 14th Amendment, and one case also brought claims under the Civil Rights Act. The trial court voted in favor of the plaintiffs in all cases. However, the U.S. Court of Appeals for the Sixth Circuit reversed this ruling and held that these bans on same-sex marriage and refusal to recognize marriages performed in other states did not violate the couple's 14th Amendment rights. In the Supreme Court, Justice Anthony M. Kennedy created a 5-4 majority in favor that the Due Process Clause does protect and guarantee the right to marry for everyone as a fundamental liberty. The right to marry is a fundamental liberty because it protects the connection between the two people, safeguards children and families with legal recognition to building a home and raising children, and has historically been recognized as the keystone of social order. With respects to these principles, there are no differences between a same-sex versus opposite-sex union, so exclusion of same-sex couples violates their due process clause of the 14th Amendment. Also, denying the Equal Protection Clause of the 14th Amendment from same-sex couples would be denying their right and equal protection under this law. The marriage rights of everyone have traditionally been addressed through both parts of the 14th Amendment, so therefore, the Constitution protects the fundamental right of same-sex couples to marry. Furthermore, the court held the First Amendment protects the rights of religious organizations to adhere to their principles, but does not allow states to deny same-sex couples the right to marry on the same terms. However, Chief Justice John G. Roberts, Jr. argued that while same-sex marriage might be good and fair, the Constitution does not address it, and therefore it is beyond the court to decide whether states must recognize or license such unions. Instead, this should be decided by individual state legislatures based on the will of their electorate. The Constitution and judicial president clearly protects a right to marry and requires states to apply equal marriage laws, but the court cannot overstep and engage in judicial policy making. Therefore, the court could only strike down unconstitutional limitations on marriage as it has been traditionally defined, but does not have the ability to make states alter their definition of marriage. Chief Justice Roberts Jr., Justice Anton Scalia, and Justice Clarence Thomas further argued that the majority opinion relied on an overly expansive reading of the due process and equal protection clauses of the 14th Amendment without engaging with the judicial analysis traditionally applied to such claims, and thus disregarded the proper role of the courts in the democratic process. Justice Scalia and Justice Thomas argued that in taking on this policy-making role, the majority opinion departed from the established 14th Amendment and created a right that did not actually exist in the Constitution. Additionally, the legislative history of the Due Process Clause in both the 5th and 14th Amendments indicates that they are meant to protect people from physical restraint and from government intervention, but that it does not grant them rights to government entitlements. Justice Scalia and Justice Thomas also argued that the majority opinion infringed upon religious freedom by legislating from the bench rather than allowing the state legislature to determine how best to address the issues and rights at hand. By allowing a majority of the court to create a new right, the majority opinion dangerously strayed from the democratic process and greatly expanded the power of the judiciary beyond what the Constitution allows. Our book by Hayes and Erford, 2018, defines heterosexism as the oppression of LGBTQ that involves prejudice and discriminatory behavior. Societal norms often value heterosexual identity and practices, which in turn may devalue the lives of LGBTQ people. According to Monk et al. 2024, not only is love and commitment motives, but most people also value legal protection and social validation in their decisions to pursue marriage. However, the social, legal, and political landscape and uncertainty of what the future holds on the rights for same-sex couples creates anxiety and depression. For many individuals in the LGBTQ community in the United States, the constant political transitions from contentious presidential elections is a top stressor. Constant heated debates and campaigns about marriage equality can leave individuals feeling uncertain about their legal and social standing, feeling threatened that they will lose their rights. Concern has grown since the overturn of Roe v. Wade, which revoked constitutional reproductive rights. Despite a rapid increase in approval for marriage equality, the opposition to same-sex marriage continues today. LGBTQ advocates fear that opposers will view the Obergefell versus Hodges ruling as a threat to heteronormative beliefs and embolden individuals with sexual prejudice to lash out against the community. Therefore, sexual minorities may be reluctant to pursue marriage out of fear of becoming targets of additional hostility. Even if legal and social support is present, the existence of opposition continues to create uncertainty among the LGBTQ community. Since there is often systematic oppression and stereotypes given to the LGBTQ identity within society, this will impact my work as a counselor, as I will likely encounter individuals that internalize the devaluation and society's negative attitudes towards their sexual orientation. It is important that we are aware of these court cases and are up to date on the laws and regulations that are affecting this community. If we are unaware of what they are facing, then this affects our competency to be able to provide them with the best quality treatment possible. Similar to how we will have to educate ourselves on working with various ethnic communities, the same goes for working with people within the LGBTQ community. I will need to keep up to date on not just laws, but best evidence-based practice, understanding the community the best way possible, and seeking supervision or corresponding with colleagues as necessary. It will also be important to not make assumptions and constantly check in with any bias or stereotypes that I may have towards my clients. I do not prefer when people are flamboyant about being a part of the LGBTQ community, just as I do not prefer when people try to force their religious beliefs on me. However, I believe that people should be who they want to be, and I really try not to have any preconceived bias about anyone. I am not religious. Even though I identify as a heterosexual female, I am supportive of other orientations and gender identities. Everyone deserves equal rights. However, I intend on educating myself more on the appropriate terminology and more about this community. Even though I have several friends within this community, I still have limited knowledge and would like to change that, especially as a future counselor. I cannot even begin to imagine the heterosexism and homophobia that they go through, so it is important to me that I create a supportive therapeutic relationship where they can be themselves and we can collaborate to best meet their therapeutic needs in counseling. Thank you for listening to my discussion post this week. I hope you have a great rest of your week.